position is in the matter of the Khan Partnership LLP and another, and Al-Shanfari.
Yes.
May it please my lords, I appear for the respondents in this matter, the Khan Partnership. They are the applicants in the security for costs application.
Yes.
My lords will see that the appellants are not represented this morning, and it might perhaps make sense to address the up-to-date position of the appellants and their representation initially before proceeding further.
Yes, I've got a council slip filled in with a whole load of names typed in, leading counsel, junior counsel, but it's put in brackets, and I don't know when the slip was filled in, but as I understand it, nobody is here today.
That's as I understand it,
yeah.
As well. My lord will have seen from recent correspondence that the appellants indicate that they don't propose to attend. I understand that their solicitors, JMW solicitors, say that they are no longer instructed and do not propose to attend either by themselves or counsel.
Yes.
Today. I also understand that...
Well, indeed, they've applied to come off the record.
Yes, my lord is right, as of yesterday afternoon.
But they are, I think the technical position is that they remain on the record, and the Court of Appeal Office has made that plain to them, that they remain on the record for one reason being that for solicitors to come off the record, there needs to be a replacement address for service within the UK.
Yes.
So that part of the Master's direction about an alternative address didn't go to the dismissal of the appeal, but went to the solicitors coming off the record. So I checked with the office yesterday, and the office have made it plain to JMW that they remain on the record until they come off, and they're not off yet.
Yes.
So that's that position. Regardless of their presence or otherwise today, there's then the question of the dismissal of the appeal.
Yes.
Which we do need to address, obviously,
yes.
because it's really the starting point. Have you got in front of you the Form 253?
My lord, I do, yes.
Right, because the position seems to us to be this. As far as the form is concerned, request for dismissal using this form will have the effect of dismissing the entire proceedings of the appeal court. Section A is to be completed where there is no respondent's notice, yes. And the appellant's notice is being dismissed with costs.
Yes.
And that is this case, isn't it?
My lord, it is. The point my lord makes is that there's no respondent's notice because we filed no cross appeal.
Yeah, there's no respondent's notice, and in any event, they have their request is on the basis that it's dismissed with costs.
It is, yes.
Now, your application is you want the cost to be assessed on an indemnity basis.
Yes.
And that's clearly an application which the respondents can make. But that isn't a part of the dismissal in the sense that you couldn't make that a condition of dismissal because it would be, well, it would ultimately, I suppose, it would be usurping the function of the court.
Yes.
Because, you know, we're here to decide that, but we can't be in an artificial position where the appeal carries on because they haven't agreed to pay indemnity costs.
Yes.
I think that's right, isn't it?
I agree with all of those propositions, my lord, yes.
Yeah.
And obviously these matters arose late in the day in terms of the listing of this application. And I hope you've seen from the correspondence sent by my instructing solicitor, that in essence what they say is that they place themselves really in the hands of the court as to how this matter is case managed, given that notice my lord has pointed out from this point. Of course, what they are very keen to do is to have the opportunity to be heard on costs, in particular as to indemnity costs. And the consequence of that, it seems to them, will be that there is at least some record or judgment from the court in relation to the conduct of the appeal, whether or not my lords decide there should be indemnity costs or not. There will be at least a record and judgment recording the actions of the appellants in this appeal, which you'll have gathered from all the papers. The respondents say falls well outside of the norm.
Yes. Well, can I assure you of this, that the respondents are entitled to make an application that the costs of the appeal be assessed on an indemnity basis. The mechanics of that we'll come back to.
Yes.
But yes, they are entitled to make that application. And having discussed the matter amongst ourselves before we started, our view is that the court would then provide a judgment,
yes,
a three-person judgment, although doubtless there'll be a lead and either two shorter judgments or two I agrees, but a judgment of the court in the usual way. So that as to that, the answer is yes, that's what will happen. So the question then becomes, I think, a question of the mechanism of that. Because I think this is right. I saw yesterday, because although the letter had said that it had been enclosed, I don't think it was, but I've subsequently seen the letter of the 25th of April, which went to the email addresses of those representing the appellants.
yes,
And that was the one that made the offer as to the amount,
yes,
and and saying that we'll then seek indemnity costs if we're here. The position is this, isn't it? If this was an ordinary case, one might think, well, the respondents are entitled to seek indemnity costs, but they'd need to sort of set out the nuts and bolts of why they say they're entitled to indemnity costs, and the appellants would have the opportunity of responding,
yes,
and then we would produce a judgment based on those points. And it seems to us that, although that will involve a bit more work on your side, and I recognise that, that's probably going to be the best and fairest way of doing it. Because you could make submissions for the next hour about why you're entitled to indemnity costs, but those would not be submissions that are in writing.
yes,
And so there would be then the potential difficulty that the appellants would say, well, we weren't there, and they may say there was a misunderstanding with our solicitors who are still on the record, all of that, who knows. And then there would be that difficulty of, well, we didn't know, we weren't there, we need this or that, or the court made an order and we want to set it aside, blah, blah.
yes,
Whereas if, and we're not envisaging very much time here, if we sought written submissions, short written submissions from you as to why you're entitled to indemnity costs to be provided, say, no later than Monday, and we require them to reply no later than the end of Friday next week, then the week of the 9th, Monday the 9th,
yes,
we, possibly as the presider in the court, I guarantee that we will provide you with a ruling, a judgment
yes,
on that application. So at the moment, that's where we think we are, and we realise that there's part of you that would say, well, can't I make my application now? They're not here, and so on. And we understand that, but we think that it's better and more secure. We can be more confident in the process if we instead adopt the method that I've indicated.
Yes, I'm most grateful for that indication, which is very clear. May I turn my back for just a moment?
No, please do. Please, do you want us to rise, or are you happy to?
Monday is a bank holiday.
So Tuesday morning. I'm reminded, my Lord reminds me that Monday's a bank holiday. I've forgotten that. So it'd be Tuesday morning, but it won't affect the timetable. Tuesday morning and Friday, 4 p.m. GMT, and the ruling the following week.
Yes, my Lord, I don't seek to dissuade you from that course, and that's a course with which the respondents would agree, and we will provide written submissions, directed to do so, short written submissions by that date.
Right. And we will then follow the usual course, because you've indicated that you want a decision. That is fair enough. So we will follow the usual course. We'll send you the draft in the normal way. That will be the subject of the embargo in the normal way. You're to reply with any typos, but only typos and grammatical errors in the normal way. And we'll and then we will hand down the judgment, and there won't be any need for anybody to attend the handout.
Yes.
So it'll follow the normal course, save that the submissions on indemnity costs will be in writing.
Yes. Thank you.
All right. Well, thank you very much. And we did keep the hearing in because we thought it was the best way of resolving the various issues that had arisen. So the appeal is dismissed. It is dismissed with costs, and it is subject to the respondent's application that the costs of the appeal are assessed on an indemnity basis.
Yes, thank you.
We need order remaking on the application.
My Lord reminds me that we should probably formally make no order on the application for security. Just formally
Yes,
no order.
I think that's right.
And leave it at that. Yes. All right. Yes, all right. Well, thank you very much.